Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning. We have 6 cases before us today. We're going to hear the first 3 and then take a short break and then come back and hear the final 3. We'll begin with 20-6175 United States versus Gross. And Mr. Autry, we are ready when you are.
Thank you, Your Honor. May it please the court. My name's David Autry, and I represent the defendant appellant in this case, Mr. Martavius Gross. It is clear from the record in this case that the district court in the final analysis abused its discretion in varying upward from an advisory guideline range of 57 to 71 months to the statutory maximum of 10 years or 120 months for Mr. Gross. And I think that's clear for a number of reasons. First of all, this is
let me interrupt, because before we get to the merits, I think we have to decide whether this appeal should be dismissed because it's barred by your appeal waiver. And you, in that appeal waiver, it looks to me like the only thing that's left is a substantive reasonableness challenge if you have an above guideline sentence. And you seem to be making procedural reasonableness challenges.
Your Honor, we did make a procedural reasonableness challenge. My argument today is going to focus exclusively on substantive reasonableness. Did the district court abuse its discretion in varying upward from the guideline range or the advisory guideline range to the statutory maximum? So that's our argument. And
does that mean for purposes of the appeal that you are giving up the claim that you briefed on procedural reasonableness?
Your Honor, we recognize that the terms of the plea agreement would appear to bar that claim. We maintain that claim only to the extent the court could conclude that if the court made procedural errors in setting the guideline range, that affects the overall substantive reasonableness of the sentence, because there's an interplay between those two things.
You know, Mr. Autry, I don't understand what the answer was. Are you giving up the procedural reasonableness claim for purposes of this appeal?
No, Your Honor, but I'm only arguing substantive reason.
Okay, all right, that's all. I just want to know where you were.
Now, why is it substantively unreasonable to sentence this defendant to the statutory maximum? Number one, this is somebody who's not even convicted previously of a felony. He was on a deferred sentence for the low-level felony of false declaration to a pawnbroker. He was only criminalized in federal court because there was an outstanding civil victim protection order. So this is somebody who's been sentenced to the maximum who doesn't even have a previous felony conviction. And he has a couple of misdemeanor convictions. He has this deferred sentence that was never accelerated for a low-level felony, yet he's getting the statutory maximum. That's number one. Second of all, the district court placed tremendous emphasis on the fact that Mr. Gross, during this incident, fired a gun from the car. Now, there's no evidence that he specifically aimed the gun at this gentleman's vehicle. There's no evidence that he tried to shoot this gentleman, but he certainly did fire a gun from the car. And
is the record correct? It indicates that he committed an assault while incarcerated on this matter?
There was an unadjudicated accusation that while he was in the Tillman County Jail, he committed an assault. He was never charged. That has never been resolved in a judicial forum, but that was a reason.
Did it affect his sentencing? Did it affect the guideline calculation?
No, Your Honor, it did not affect the guideline calculation because there was no conviction.
Was there any evidence before the district court regarding that assault?
The only evidence was what was contained in the pre-sentence report based on a report that was done by the Tillman County Sheriff's Office, which runs the jail. There was no testimonial evidence. There was never a charge brought as a result of this supposed assault or anything else.
Was there any discussion of it at sentencing?
There was some discussion of it at sentencing, yes.
All right, thank you.
So in discussing the 355-3A factors, the district court was pretty clear that Mr. Gross had extensive criminal history that started when he was only 14 years old and involved assaults and batteries, including the one that had happened since he was arrested and detained. Given that, hasn't the judge adequately explained the reason for the upward variance?
I don't think so, Your Honor, because number one, all of those instances that were cited by the court were old instances, primarily when Mr. Gross was a juvenile. There were a couple of alleged domestic assaults that never resulted in criminal charges. There was this alleged assault in the jail that never resulted in criminal charges. So when you look at Mr. Gross's criminal history, which is a criminal history 3, even though he has no previous felony convictions, that more than takes into account Mr. Gross's criminal history. If it's going
he was 22 at the time he was sentenced, correct?
Yes, sir.
All right.
And he, according to the district court at sentencing, there'd only been 11 months since he was 14 when he wasn't detained, incarcerated, or facing charges or on probation. There was really a limited amount of time for him to act. And what the court said is when he had an opportunity, he committed crimes.
Well, Your Honor, most of those were unadjudicated, and I simply look at what his record of convictions were.
But that's not just you're not limited at sentencing to just the convictions in terms of selecting the sentence within the guideline range, are you?
No, you're not. But I would suggest that when you're dealing with unadjudicated acts or cases that were investigated for which no charges were brought, certainly that can be taken into account. But I think the weight to be given it should be very slight. And when you compare that to Mr. Gross's actual criminal history, no previous felony convictions, one deferred for a minor state felony, the criminal history category more than takes into account all of that. And that's related to our argument that this sentence was ultimately substantively unreasonable because of the weight put by the district court on the shooting incident. That was fully taken into account under the advisory guidelines.
So how about this idea? Maybe the district court decided that the nature of the past offenses and the shooting crime here were actually underrepresented. Maybe the district court looked at it and said, gosh, these were all charged, but they never did anything with him on these violent acts of domestic violence he committed. And I think they're underrepresented in his criminal history score and in guidelines calculation. So I'm going to vary upward. What do you think about that?
I would disagree with that, Your Honor. I think that would constitute an abuse of discretion because the criminal history category 3 actually could be said to overrepresent the actual criminal history of somebody who had no previous felony convictions whatsoever. All that's taken into account. The shooting is taken into account because he gets 4 points up for possessing a weapon in the commission of another crime. So that's fully taken into account in the advisory guidelines. The criminal history is fully taken into account in the advisory guidelines. It's questionable.
Let me ask you this. Should somebody who is convicted of that possession crime, who just merely had the gun sitting on the passenger seat next to him, should a second person who possessed the same gun but pointed it at someone in a threatening fashion, should they get the same sentence?
I think probably the person who pointed the gun in a threatening fashion should get a higher sentence than the person who merely possessed it or constructively possessed it because a firearm is in the car. However, that was fully taken into account in the advisory guideline calculation because he got a 4-point increase above the base offense level for using the weapon in the manner he used it. He also got a 2-level increase because the firearm was stolen. There was no evidence that Mr. Gross stole it or was even aware that it was stolen. But the law in this circuit is it's a strict liability enhancement. So all of that is adequately taken into account. And I think particularly a 10-year maximum sentence for somebody with no prior felony convictions is unreasonable when you look at it from a global perspective. The way we're going now, the Second Amendment is going to be exalted above all other rights contained in the Bill of Rights. We have open carry, we have concealed carry, we have carry an assault rifle around on the streets. We've got, you can carry a weapon regardless of whether you're qualified to carry a weapon or trained in carrying a weapon. We can carry weapons into public places where it's not strictly prohibited.
We get the point. We get the litany. What's the point?
The point is a person with no prior felony conviction should not be sentenced to the maximum of 10 years imprisonment when virtually everybody in the country is running around with a gun.
Well, not everybody in the country is running around with a gun that then they shoot at another in the vicinity of another vehicle after a road rage incident. I mean, this isn't a Second Amendment issue here.
I understand that, Your Honor. But I think all of that is relevant. The way we view guns in this country currently is relevant to determining whether or not somebody with no prior felony convictions should get the statutory maximum. And I would reiterate that certainly nobody is condoning what Mr. Cross did with the gun during the road rage incident. It's wrong, it's stupid, and it ought to be punished. And it was fully taken into account under the advisory guidelines. So
what
that's
about under the 3553A factors? What about the idea that the public needed to be protected from your client? I mean, the district court had before him a young man who, for most of his teenage and adult life, had been involved in violent activity. I mean, wasn't the district court allowed then to consider that and place great weight on the past violent conduct in saying, look, the public needs to be protected from this person, so I'm going to give him the max?
I don't think that there's any question that protection of the public is a relevant circumstance, and I think that could have been fulfilled with a sentence within the advisory guideline range of up to 71 months, the top of the guideline range. And again, Mr. Cross's violent past largely resulted in no charges being filed. They're all unadjudicated. If he's really that bad a guy, why wasn't he charged with a drive-by shooting in state court as a result of this particular incident? He wasn't. Maybe that's just because he got charged in federal court. I know that happens all the time where a state case is not pursued in lieu of federal prosecution. But to emphasize how supposedly violent this man is without also giving due weight to the fact that it resulted in no felony convictions of any kind is taking it a step too far, particularly when you're talking about sentencing somebody to the statutory maximum. Unless there are any further questions, Your Honors, I'd like to reserve whatever time I've got left. Thank you.
Thank you. Mr. Krager.
Thank you, Your Honor, and may it please the court. Stephen Krager on behalf of the United States. The district court properly sentenced Mr. Gross to 120 months imprisonment. Mr. Gross has challenged the substantive and procedural reasonableness of his sentence, and as this court has already noted, and as Mr. Autry explained, the procedural aspects of the appeal are barred by an appellate waiver. Mr. Autry hasn't discussed the appellate waiver, so unless the court has any questions for me on it, I think I'll bypass that as well.
Let me ask you this. The argument seems to be that the procedural aspects of the sentence calculation is so intertwined with whether the sentence is substantively reasonable that we can't really break them out and we have to look at both.
Well, Your Honor, this court has enforced appellate waivers to, using the exact same language, to dismiss procedural issues like this, and in numerous cases, in Tanner and Goldberg and Gomez and in Green. The case that Mr. Autry had relied upon, which I believe is Barnes, dealt with a very specific procedural issue and didn't deal with a waiver. The procedural issue in Barnes, if I remember correctly, was the adequacy of the explanation of the sentence. And where a sentence is inadequately explained, then it becomes very difficult for this court to review the substantive reasonableness of the sentence, because typically this court defers to the weight the district gives. But here, where the attack is on the guidelines, what this court could do and should do is dismiss the procedural components and act as if those procedural components simply had not been raised. Because simply put, Mr. Gross should not have raised those issues in his appeal if he was abiding by the terms of his appellate waiver.
Well, they're sort of the same, aren't they? Because he, for example, we talked a lot about how there's no evidence that he was pointing the gun at the other car, and the district court took into account that he had shot into another car. And part of his procedural analysis was that that would need to be proven beyond a reasonable doubt. And there are several things like that. So, I mean, isn't this sort of mixed up? I mean, you're not suggesting that we can't consider that evidence, are you?
No, to the extent that there was no evidence, say, of Mr. Gross shooting at the vehicle, that might be something that could be considered in a substantive reasonableness claim. Where you start getting into factual questions, and this goes again into the Barnes issue, where the line, there is a point where it starts getting fuzzy. Maybe that's an issue that could be raised. But ultimately, this court could and should, and I think Friedman, this court's decision in Friedman note 10 said, essentially, we take the district court at its word, even in a situation like that. But to address the specific about the Mr. Gross not shooting, or there not being evidence that Mr. Gross pointed a firearm at the vehicle, I was planning on getting to that. There actually is evidence, and that is at page 29, paragraph 14 of the record on appeal, which is in the PSR, and then also at pages 5 and 6 of volume 1 of the supplemental record. And I believe that is a police report where Mr. Gross admitted that he pointed a firearm at AA. Now, true, there was no bullet hole, so he must have missed the car, or he may have lifted the gun up, but he pointed the gun at the car. So unless there are any additional questions about the procedural issues, I'll talk about the substantive issues. There are a couple of points that I strongly disagree with Mr. Autry on. First is his claim that it's per se unreasonable for a 10-year sentence to be given to somebody who's never been convicted of a felony. Congress, by enacting a 10-year statutory maximum for a violation of 922 G8, has provided a 10-year statutory maximum, thus suggesting that Congress believes there are situations where such a statutory maximum sentence is reasonable. Another issue that I had with Mr. Autry's argument is his claim, essentially, that a sentence outside the guidelines is per se unreasonable. It's presumptively unreasonable. This court has explained, the Supreme Court has explained time and time again, that a sentence outside the guideline range might not be able to be entitled to a presumption of reasonableness, but it is not presumptively unreasonable. And in fact, going back to Barnes, this court explained that the district court could use conduct contemplated by the guidelines in varying upwards or downwards, as the case may be. And here, as the court, I think, is fully aware, as indicated through its questions, Mr. Gross had an extensive criminal history, going all the way back to when he was 14 and he sexually assaulted a 9-year-old boy. And then going at 17 when he assaulted 2 OJA employees. And then every year from 19 until the instant offense, and even after the instant offense in Tillman County, engaged in violent conduct. Yes, a lot of that violent conduct was against his ex-girlfriend, but still engaged in significant violent conduct.
So let me ask you this. Before the district court, were these instances of violence denied by the defendant? For example, did he deny that he assaulted the juvenile officers? Did he deny that he beat up his girlfriend? Did he deny that he assaulted the kid when he was 14?
I don't believe so. I believe the only arguments were, as Mr. Autry is making, that either they were too old or that they simply weren't given criminal history points and thus should be ignored. But just because something's not given criminal history points doesn't mean that it can't be taken into account under 3553A.
Okay.
And here, in addition, the district court performed the balancing test that was required to perform. It considered on the aggravating side all of Mr. Gross's violent conduct, his conduct here in shooting at a vehicle, traveling along a highway at highway speeds, creating a danger not only to the vehicle he was shooting at, but a danger to any other vehicle on the roadway, but also considered his mitigating evidence. Page 29 of Volume 3 of the Record on Appeal, the district court explicitly said it considered his mitigating evidence. At the end of the day, the question for this court is not whether it might reach a different sentence, but whether the sentence reached by the district court fell within the broad range of rational sentencing choices. The United States admits that it was within that broad range of rational sentencing choices. Unless the court has any additional questions, I'd be happy to ask the court to affirm and yield back the rest of my time.
Thank you.
Thank you.
Mr. Autry, you have a minute.
I did have a question. I was muted. I didn't have fast enough hands.
I'm sorry.
That's all right. Mr. Krager, do we know how much of the defendant's life he's been incarcerated?
I do not have an independent recollection right now. I would defer to Judge McHugh and or her clerks who suggested that it was 11 months, but I don't have that written out where I can
okay. All right. Thank you.
Easily reference that, and I apologize.
No need.
Okay. Mr. Autry. Oh, wait, we need to, okay. The time is reset. So, oh no, there we go. Okay.
Thank you, Your Honor. A couple of quick points. We are not arguing that a 10-year sentence is per se unreasonable across the board. Certainly, Congress has provided that the maximum punishment for this offense is 12 years. The question here is whether a maximum sentence for somebody in Mr. Gross's position who has no previous actual felony convictions, notwithstanding his juvenile record and all these unadjudicated acts, is in fact a reasonable sentence. And we believe that it's not a reasonable sentence for the reasons we've already stated, primarily that the things the court took into account in raising the sentence well above the advisory guidelines were already taken into account by the probation office. Can unadjudicated acts be used in calculating punishment? Well, absolutely. They were used in this case. The question is, was too much weight put upon them? And we submit that it was. In answer to the question as to whether there were instances of violence, alleged violence in Mr. Gross's past that were denied at sentencing, the answer to that is no. And I see my time is almost expired. We would ask the court to remand this case for resentencing because the sentence was substantively unreasonable.
Mr. Autry, refresh my memory. Did the PSR, what was their recommendation?
The recommendation, Your Honor, was advisory guideline range of 57 to 71 months for a defendant in criminal history 3, which is where they placed Mr. Gross, total offense level of 23.
I understand that. Was that their recommendation, 71 months?
They didn't make a recommendation. And what's interesting is at the end of the pre-sentence report where they say, are there grounds for an upward departure or variance? The probation office found no grounds for either an upward or a downward variance.
Okay, thank you.
Thank you, Your Honor.
Thank you. We will take this matter under advisement and turn to the next matter before us as soon as counsel is present. And that is 20-1386, United States versus Garcia.
May it please the court, Bishop Gruwell on behalf of the United States. I will attempt to reserve 2 minutes of rebuttal time. The United States delayed its prosecution in this case to allow a fellow sovereign to complete its prosecution on attempted murder charges and a state gun charge that had substantial overlap with the federal gun charge in this case. It then moved to writ the defendant over from state custody 1 day before his state sentencing was scheduled, so that it was then able to actually bring him over from state custody a few days after that. That approach is consistent with the principles of comity and with respect for another sovereign that are inherent in this court's precedents.
But we don't always say that waiting for the state to prosecute is a justifiable excuse for purposes of the speedy trial requirement, do we?
No, what you do is you look at that as a possible reason for a government victory on the second factor, the Barker factors. And to make that analysis, you look at basically 3 sub-factors, any of which, if they're present, that's sufficient to consider it a just justification to delay for the state proceedings. And here we certainly met the very first sub-factor, the overlap on the charges. This is the one clear error point that I think we're really pressing on appeal, that the district court clearly erred when she found that there was no overlap between the federal charges and the state charges. She said that the state charges just went to the July 5th shooting at the police, and the federal charges just went to the July 3rd shooting at the Kmart. That's clearly wrong from the indictment. We have a federal gun charge that charged a continuing offense that went from July 3rd through July 5th. So if there had been, for instance, identity concerns about whether he was the person doing the shooting at the Kmart, we still could have proceeded on that federal gun charge based entirely on the events of July 5th, which underlie all of the charges in the state case. And so there was substantial overlap here. And the reason go ahead.
There may be overlap. I'm not sure if I'd say there's substantial overlap. I mean, there is some overlap.
In Medina, this court said there was overlap because it was federal gun charges and state gun charges. That was enough there. And we've got much more than that here. It's all the evidence underlying the federal gun charge. All of the state charge would be in that particular case. And we've made particularized reasons why that was a concern, that overlap was a concern. We explained below that he may have inconsistent positions in the state court and the federal court. And by basically delaying, we were helping him to not actually have those conflicting positions or to see if they would occur. For instance, he could have said in the state court, yeah, on the 3rd, he could have tried to introduce evidence that on the 3rd, he did fire into the ground to show that 2 days later when he was firing, he wasn't actually trying to kill the police. He wasn't attempting murder after deliberation, which was in conflict with what he wanted to say in the federal court, which was that he hadn't fired the gun at all. Now, did that happen? No, because he eventually pled to assault charges. But until he pled guilty in June, just a couple months before we brought him over, there was no way for us to know that. And so that was certainly a reason to justify delaying for the state proceedings here. We also think that there was the inherent complexity that this court recognized in Nixon as a reason. We have attempted murder charges here. The elements of those are just as complicated as a murder charge, and that also justified us delaying and therefore winning Barker Factor 2.
Counsel, it's not uncommon, is it, that in cases that are really assault cases, that they're charged as attempted murder cases, right? That's not uncommon, correct?
I suppose if you had something that looked like it could be an attempted murder, that wouldn't be uncommon, yeah. Here he was firing it at the police. I
understand. My question is it uncommon that true assault cases are originally charged as attempted murder cases?
I don't know how common it is, Your Honor. I would say it's not rare that you would have that. I mean, if you hit somebody, it's probably going to be an assault case without, if you hit them with their fist, that's going to be an assault without attempted murder probably. But
let me ask you this. Now you didn't have any hearings on this, so everything was submitted on paper, correct?
Correct.
What evidence was there before the district court as to the complexity of the state case?
There were just the allegations about it, it being an attempted murder case, and that would be inherently complex.
Well, was the state charge in an indictment or an information or a criminal complaint?
I believe it was a complaint. It's in the record attached to, I believe, the defendant's reply brief in this matter.
All right, and that complaint was was evidence the district court had?
The district court had that, yes.
Did the district court have the plea agreement?
I don't believe that. I can't remember if the plea agreement is in the record or not.
Would it be fair to say that the only thing that the court had as factual evidence regarding the complexity was the complaint filed in the state court?
I think that's fair to say.
All right, thank you.
And I believe because we're talking about legal complexity here, it would really be an elements more like a categorical approach as opposed to factual complexity. We're not arguing sort of the factual complexity. We're just arguing the inherent legal complexity of attempted murder charges. But even if we didn't win on the complexity point, the fact that we had this overlap with potential conflict on its own is enough as a just reason to delay here, given that we would be merely speculating about how he's going to defend his trial in state court.
Is there a state weapons charge in that complaint?
There is. There is a state weapons charge, yes.
All right, but he pled instead to a lesser included of the attempted murder, assault, and all other counts were dismissed.
He just pled to the assault and all the other counts were dismissed.
Okay.
And had the state gun charge not been dismissed, I suppose it's possible we might have dismissed the federal gun charge here. Again, something we wouldn't know until he actually pled guilty. Okay. Regardless of whether we were to win on factor 2, it's appropriate for this court to find that no speedy trial violation occurred here and reinstate the indictment on the prejudice prong alone, prejudice factor alone. This court has recognized that if a defendant fails to meet their burden of showing prejudice, that effectively eviscerates their claim. And we're pressing 2 legal arguments on this. The first is that the district court legally erred by effectively excising the causation requirement from showing prejudice based on speedy trial delay. And the second is a legal error where she concluded that she could, on the 23 months of pretrial incarceration alone, grant the prejudice prong to the defendant. Both of those are legal error. Judge McHugh?
Yeah, let me, on the second piece of that, we've got it set out as the purposes of the Speedy Trial Act, and as separate purposes, there's the prejudice to the defendant specifically on evidence in the case, but we also list as a factor excessive pretrial detainment as a separate factor, and I guess the anxiety that causes. As I understand your argument, you're saying that none of the other reasons matter if you can't show specifically that there's been prejudice in your defense because of the delay, that you lose on the prejudice prong. Am I correct in your argument?
We are saying that, correct, that those other 2 factors are basically pluses that you consider, but there has to be at least some hindrance to the defense. That's what I believe Judge Murphy said in the Toombs decision, said we're giving them the first 2 factors, but it doesn't matter that he spent 22 months pretrial incarceration. He has no prejudice here, and so he doesn't win factor 4. Moreover, this court in Black did the same thing with 23 months, which is the exact same amount of time here if you assume he could have been released on federal detainer. And in Larson, it said 31 months was not enough, which is longer than the defendant would have spent in time here.
Sorry, go ahead.
No, you continue. Oh, no.
Okay, turning now to the security footage, the the actual prejudice to the defense. If the government knows that they are going to bring this action, but the defendant doesn't know because he hasn't yet been indicted, isn't it the government's responsibility to make sure that the evidence is not destroyed, the security footage?
So the Supreme Court said in Arizona versus Youngblood that as long as there's not bad faith on the government's part, that there's not some broad obligation to just retain everything. And we have no reason to believe that the security footage missing here, assuming there is security footage missing here, it would have necessarily been relevant. What likely happened here is the government said, send us over the video you got on this particular incident, and that other video had nothing to show about it. Arizona versus Youngblood says, if you're going to rely on just the government not preserving evidence, you have to have some bad faith. And that's never been alleged here. It's certainly in the speedy trial context, this court in Frias and Medina says there's a causation requirement that you have to, if you're going to have the prejudice prong go to the defense based on the loss of evidence, that loss of evidence has to be caused by the speedy trial delay. And where evidence has already been destroyed before the indictment has even been filed, it's not the speedy trial delay that has caused any evidence to be lost. And so it's certainly not prejudice under the speedy trial analysis.
As I understand it, there was the tape was destroyed about 30 days after the incident?
36 days.
36 days. All right. And how many days after the incident was the federal indictment returned?
It was about 2 months. So the event was July 3rd, 36 days after that, sometime in August, it was destroyed. The indictment was near the end of September.
Is there any evidence in the record when the U.S. Attorney's Office started investigating this?
I don't believe there's evidence in the record of that, no, Your Honor.
Is there any evidence in the record of how the referral occurred to the U.S. Attorneys on the weapons issue?
There is not. And I would also point out that on the fourth factor, the burden is on the defense to show the prejudice here.
Even after they carry their burden on the first factor.
Yes, the burden still remains with the defense after they carry it on the first factor. Carrying on the first factor
and
incident.
Correct. All it shows is security guards who are viewing the previous security footage, and it shows a conversation where the officer's asking about it, and it appears very clearly that the security officer is pointing to footage that was then never produced. And it was critically important footage because we're talking about a case where there's another motion that was filed by the defense. The government did not place this on a record, but you can see it on the docket, and it's mentioned in many of the other motions that are on the record. A motion to dismiss two of the most serious charges, the robbery charge and the 924C, saying this was not a robbery. This really is not much of a federal case. This was a shoplifting incident. And after the shoplifting incident was completed, there was violence in the attempt to escape. And that is the footage that was missing. So we're talking about a truly important thing that was missing. But again, even if Your Honor doesn't accept that there's some difference between the denial of the motion where the government never said this was destroyed after 36 days, and the denial of the motion to reconsider where they said, oh, you should have held a hearing, here's some evidence from yesterday, there's still this third reason, and that has to do with the pretrial incarceration.
Well, let me ask you about that. Under our decision in Toombs, can that standing alone be enough to satisfy
yes, Your Honor.
Prejudice prong? I mean, I'm not sure I read that case that way.
I think, Your Honor, that every case where this court has said, oh, this pretrial incarceration isn't enough is a case where the person was in federal custody during the specific case where there was delay. The Supreme Court, if you look at Seltzer specifically says by maintaining a federal detainer rather than holding a detention hearing, the government assured that Mr. Seltzer would remain in jail until the federal prosecution commenced. This type of prolonged pretrial incarceration is a well-established type of prejudice that a defendant may rely upon in making a Sixth Amendment speedy trial claim. The government is making an incredibly aggressive assertion. They're saying you always have to have prejudice to the defense. And it's very clear that that's not true. If that were true, I think that sometime in the last 50 years, the US Supreme Court or this court would have said that, and that's never been said. If I may address some of the things the government said at the beginning.
Before you go, on complexity, do you agree that the only evidence is the complaint filed in state court, the criminal complaint?
I believe so. And my understanding of the complaint that was filed is that it was really just a list of the charges. I don't remember there being like a description of what happened.
So that's all the district court had in ruling on complexity.
I believe so. And then also there was a mention of, so you asked earlier, Your Honor, about whether the plea agreement had been provided. The plea agreement was not provided, but a description of the facts that it had ended in a plea was provided.
Here's my question. So the facts are undisputed as to the underlying facts on the complexity. Doesn't that make the determination of complexity a question of law? The facts are undisputed. Clears, and then you go on. Does that complaint, as a matter of law, indicate that it's complex?
I don't think, Your Honor, that is the question to be asking, because I think the question, the government tries to say, they literally said there are 3 sub-factors. If they're present, that's sufficient for us to defer. That is not the law of this circuit. That is absolutely not the law of this circuit. In Seltzer, this court says that the government is required to show why the circumstances require the conclusion of the state proceedings before the federal proceedings can continue. The government has never done that. They've asserted that there's overlap. They've asserted that there's complexity. But the real factual question for the district court was whether the government had shown that they had to defer. And they absolutely didn't. None of the things that the government mentioned have anything to do with serial prosecution versus simultaneous prosecution. There's absolutely no reason.
But that suggests that even the general concept of comedy is irrelevant, and that's not so.
I agree that it's not irrelevant, but there's a very good description in Seltzer of a circuit split, 3-way circuit split, where there's at least one circuit that says, never may you defer. There's several circuits that say, usually you can defer. And then this court sat itself in the middle and said, yes, deference makes sense in some circumstances, but you really have to show that it's necessary in your case. And the government did not do that here. They keep referring to Nixon. That was, again, something that applied clear error. There just is not a situation where a district court has said this is not complex, that there's nothing that means that the government couldn't have worked a little bit harder and made this work, where this court has then overruled that decision. This court simply hasn't done that. The government is relying on cases that were clear error review of government wins to argue that in this clear error review of a defense win, this court is somehow legally compelled to say that the district court abused its discretion in making this finding. And it simply isn't. In Nixon, this court did not say murder cases are inherently complex, you always defer. They said, we understand that murder cases are generally inherently complex. And in this situation, we are deferring to the decision of the district court based on the facts of this murder case, that this murder case was complex and that was a reason to defer prosecution. So the government repeatedly is not citing the law correctly and is not giving this court the correct flag posts to be able to follow this court, for this court to follow to the correct decision.
And I think unless there's questions from the bench, I think you need to sum up because you're over time.
Absolutely. Your Honor, again, I think that the real issue with the government's appeal is that they don't separate the original denial of the motion to dismiss from the denial of the motion to reconsider, which was simply a motion to say you should have held a hearing. And finally, if this court decides not to affirm, I would request that you do remand for an evidentiary hearing.
Thank you. Mr. Crewell, we're going to give you 3.5 minutes because that is how far we let the defendant go over. And let us just set the clock. We're not quite there yet. All right, we're ready to proceed. Thank you.
Thank you, Your Honors. As a first matter, I just encourage, I trust the court will read the cases and determine whether we've cited the law correctly. I think you'll find that we have. On Seltzer, there was also a hindrance to the defense prejudice in that case. In our reply brief, we talk about the numerous other forms of prejudice in Seltzer, and so it was not just the pretrial incarceration as it is here if you take out the video prejudice. On the video prejudice, if you look at her reconsideration motion, the judge here assumed the facts were, as we said, that the video had been overwritten after 36 days, and she said that still didn't matter because it was our fault that the video wasn't there. As far as whether we should have had this 36 days ready long beforehand, we didn't know it was relevant until they filed their motion to dismiss on speedy trial grounds. It's only when they say, hey, this video evidence is lost and therefore we're prejudiced that becomes relevant. And we note in our response, we've reached out to Kmart. We haven't heard back yet, but we did ask for a hearing, and we were assuming if we get a hearing, we'll get to present that. We finally had it in time for our motion for reconsideration. We present that facts. At no point in their reply brief below to our response or at this point on appeal have they given any indication that video would have still been in existence prior to the indictment. And you don't have to have certainty. You can, the fact that we have that there's a policy that this is going to be overwritten is enough to suggest that this was in fact overwritten. It's their burden to show that's not the case somehow. Was
the initial briefing on the motion in the federal district court, was that completed in July of 2020?
I believe that's when the order came down and we filed our reconsideration motion. I believe it was a little bit before that.
Okay, and the reconsideration order was September, I believe, correct?
I think that's right. Yeah. The reconsideration, yes, the reconsideration order was July of 2020, yes.
Were Zoom hearings being conducted in the federal district court in Colorado at that time?
I believe we were doing video conferences and occasionally doing video sentencings if the defendant was willing to waive for a sentencing of that sort. Okay. I don't think we were doing a whole lot of trials at that point, but there were hearings. Right. And then I would point out, if counsel really feels that there are other motions that should be in the record, opposing counsel always has the ability to supplement the record if they'd like to do so. And this may be a shoplifting incident, but it's a shoplifting incident where the guy then threatened employees at the Kmart and fired a gun in their presence. And I think that's a very different circumstance and warranted bringing federal charges here. Besides the fact that he is a felon who has felon status in possession of a firearm, we bring those cases in federal court. It was an appropriate prosecution.
What would you contemplate would happen if there was a remand for a further hearing?
I would contemplate that there'd be nothing different on the video. There may be findings that, yes, indeed, he would have been released on bond. Maybe there wouldn't be, but again, that wouldn't change anything. There may be a finding that there weren't logistical difficulties or that there were, but again, that wouldn't change anything given the prejudice prong, given the third factor, and given the overlap in the cases. Okay. And we would ask this court to reverse the district court's order, reinstate the indictment, and hold that no speedy trial violations occurred. Thank you.
Thank you. We will take this matter under advisement and turn to our next case, which is 21-1153, United States versus Carillo. Mr. Shaw.
Thank you very much. May it please the court. My name is Jason Shaw, and I represent Appellant Manuel Carrillo. In this case, the district court abused its discretion by failing to reduce and preserving a 60-year sentence on a crack cocaine offense, for which Mr. Carrillo asked for the First Step Act to apply to reduce his sentence, and the court left in place a 60-year sentence when the revised statutory maximum applicable to the offense is only 40 years. In doing so, the court abused its discretion and left us only, left us only with a footnote explaining its rationale. However, this court interprets that footnote, it doesn't matter because the district court abused its discretion. And the one interpretation of that footnote.
Well, isn't the court correct that once it denied relief on count 1, that anything it did on count 17 would have no impact on the amount of time that Mr. Carrillo spent in prison?
But, Your Honor, the problem with that is...
Well, yes or no first.
It did not change his sentence. That's correct, Your Honor.
And could not. A ruling on count 17 could not then change his sentence.
Not at presently. That's right, Your Honor. But
okay, so I want you to focus for a minute on whether, I know the court appears to have decided this on standing, but there's another justiciability issue that we look at, which is called mootness. And if the court cannot give meaningful relief, even if that inability arises during the pendency of the case, the matter becomes moot. Didn't the court do exactly what it should have done when the matter became moot, which is dismiss that claim without prejudice so that if it ever had an ability to affect his sentence, you could bring it?
the problem, Your Honor, is that it's unclear from the footnote whether the district court dismissed the claim without prejudice, or if in doing so, the district court said arguably that count 17 was a covered offense. But the problem lies in that the amount of crack cocaine involved in this whole case was the same physical crack cocaine for count 17 as it was for count 1. And if the district court determined, which it did, that count 1 was a covered offense, then it's illogical that it couldn't also be determining that count 17 was a covered offense. And if the court determined that count 17 was a covered offense, at some point in the future, someone could argue that Mr. Carrillo has lost his, quote, one bite at the apple because the court has ruled on the merits that it was a covered offense and that the district court wasn't going to address it.
I mean, that's sort of an unfair reading of the decision, though, isn't it? Because isn't the clear import of the decision that I'm not reaching the merits of count 17 because I can't do anything with it, and I'm going to dismiss it without prejudice, which makes it clear that you can bring it back. I mean, the argument was presented below that, hey, this is a one bite at the apple statute, and if you kick me out without ruling on this, I'm never going to get to bring it up again. And the district court basically said, yes, you are, because I'm not ruling on it. I mean, how do you deal with that?
Your Honor, if that's what the district court said, then it failed to reach a decision after a complete review of the motion on its merits, and Mr. Carrillo would then preserve his right under the First Step Act to come back later. But it's unclear that, at least in my reading, that that's what the district court did, because it left us only a footnote that gave three kind of rationales, one of which was the reliance on Manny, this court's ruling in Manny, which is entirely different than the case at Barr, because in Manny, the defendant had overarching sentences that were greater than the covered offenses that the court was addressing. Here,
well, the difference between Manny in this case is the difference between standing and mootness, right? From the get-go in Manny, there was no standing. There was no way the court could have given the relief that was requested. Here, if the court had exercised its discretion and reduced on count 1, it could have moved on to count 17 and reduced that as well and given some relief. But once the court decided I'm not giving relief on count 1, There was nothing the court could do with respect to count 17 that would have any practical consequences in the real world. So the court did exactly what it should have done. It said, I can't rule on this, and saved it for another day, making clear that it wasn't making a ruling on the merits.
Your Honor, if I may, it depends when the court made that mootness determination. The issue clearly wasn't moot when it was presented by Mr. Carrillo in his motion, and the court arguably—
And that's why he had standing.
Correct. But can the court make the issue moot in the middle of its—
Yes, it happens all the time. If you rule on one thing, another thing is no longer has any consequences. It happens all the time that a matter becomes moot during the pendency of the action.
Your Honor, if it then became moot, presumably Mr. Carrillo's count 17 motion was not adjudicated or reviewed after a complete review on the merits, and he preserves that right. And we're not asking this court to rule that he's given up that right if the motion became moot at that point. But what we're saying is by choosing by arguing that it wasn't moot, the court used that as a hook to preserve a sentence of 60 years when if it is a covered offense, which arguably the court effectively decided, then the maximum statutory punishment is 40 years. And it can't be moot ever if there's an illegal sentence that's kept in place, because the harm is that he's serving 60 years on a statute that now requires a maximum of 40. And that's a pretty significant harm, given that there were two statutes passed over the past 12 years, addressing crack cocaine sentencing disparities. The first one in 2010 changed the statutory thresholds from, in this case, from 50 grams to 280 grams. And Mr. Carrillo's offense, both of his offenses, involve 51 grams of crack cocaine. And he falls like right in the smack bullseye of what that modification was. And then in 2018, when the First Step Act passed, it gave defendants the chance to seek relief as if the Fair Sentencing Act of 2010 was in place at the time of the covered offense. And a court doing that calculus would have to find that 51 grams of crack offense was only punishable now by 40 years in prison. And Mr. Carillo is serving a 60-year sentence, which I acknowledge there's not too many 60-year federal crack cocaine sentences that even exist, much less would come before this court.
So let me ask you this. Do you agree that if we determine the district court did not reach the merits of count 17, that your case is over? That you lose at that point?
Only, Your Honor, if the court has the discretion to keep in place a 60-year sentence for a statutory maximum offense of 40 years. If the court doesn't—
what's our discretion to get rid of it when we have a case that says if you can't address an issue if it won't change the ultimate sentencing outcome? I mean, in this case, count 1 is going to stand. You didn't appeal that. So he's in for 720 months under count 1. And if we then say, look, you didn't appeal that, so he's in for 720, there's no relief available to you, and the district court didn't reach the merits, I mean, isn't that the end of it?
Well, Your Honor, that sounds like the concurrent sentence doctrine, which is not jurisdictional, but discretionary. And our argument is that if that's the basis for saying it's moot, then the court abused its discretion, because preserving a 60-year sentence where the statute says a maximum of 40 years is per se an abuse of discretion, and the concurrent sentencing doctrine can't save that.
Well, that wasn't the basis for relief that you brought, though. Let's just change it up a little bit. I mean, you do agree that, like, under a Manny fact pattern, where say you came in and asked for this relief but didn't challenge count one, you lose at step one then, right? I mean, if you come in and you say, hey, look, this is an illegal sentence. It can't possibly be more than 40 months or 60 months or whatever you want to, or I mean, 40 years, I guess, is what you can't possibly have more than that. If the district court would have said, yes, but you're serving 720 months on another sentence that you have not challenged, so I can't give you relief. You agree that would have been correct, right?
Well, except, Your Honor, if the two acts passed by Congress require, as the Fourth Circuit said in Collington, that a 60-year sentence now needs to be reduced to no more than 40 years. Okay, so you're challenging our decision in Manny then, suggesting that it's improper. No, Your Honor, Manny had overarching convictions that were not crack cocaine offenses that the First Step Act could address. So this one does too. He upheld the count one based on the methamphetamine amounts. And that's kind of the problem, Your Honor, is the court did all of the analysis for the crack cocaine involved in count 17 as to count one, and it literally walked down the road. And then it said, but we're not going to do count 17, even though effectively its decision had checked all of the boxes. The court just said in a footnote, arguably we should do that, but we're not going to do it here. And that's the problem, is that could be construed at some future point as being a complete review of the merits. And if there's no further questions from the panel, I'd like to reserve my last minute 45.
You may do so. Mr. Brenton?
Good morning. May it please the court. I am Kyle Brenton on behalf of the United States. There is no dispute in this case that, in light of the district court's decision not to reduce the sentence as to count one, there was no order the court could have entered as to count 17 that would have reduced Mr. Carrillo's sentence by 1 day or 1 minute. And Mr. Carrillo has not appealed the ruling as to count one. The questions then for this court as to count 17 are whether, one, the court retained jurisdiction to do anything with it in light of Manny, and two, if the court did have jurisdiction, did it have any legal obligation to reduce the sentence on count 17 consistent with its discretion under the First Step Act? Now, the answer to both questions is no, and the district court should be affirmed. But I think this court's attention is quite properly on the jurisdictional issue. The reality in this case is Manny meant what it said, and it's binding on this court. A criminal defendant has standing, and obviously Manny was a standing case, and we can talk a bit more about that in a moment, but has standing to seek a sentence reduction only where the reduction sought will actually reduce the amount of time that defendant spends in prison. In other words, only where the court can grant relief that is meaningful in the real world. And Mr. Carrillo suggests that the difference between this case and Manny and this court's decision in Ellis as well is that at the outset, in Manny and Ellis, there was a controlling concurrent sentence that wasn't even a covered offense under the First Step Act. So the court never had any ability to do anything. Whereas in this case, at the outset, obviously the sentences on count 17 and count 1 are both for covered offenses under the First Step Act. But that's a distinction without a difference. I think, as Judge McHugh observed, I think the difference between Manny and this case is simply the difference between standing and mootness. As I say, there is no dispute that as soon as the court made its decision as to count 1, it lost the ability to grant any meaningful relief on count 17. And I think this court's decisions and the decisions from the Supreme Court on the mootness doctrine absolutely encompass this situation. The court may have had jurisdiction at the outset, but given its rulings over the course of the case, it lost jurisdiction over count 17. And Mr. Carrillo uses the phrase, the court choosing to strip itself of jurisdiction. That's a dramatic way to put it, but I think the reality is a lot more mundane. I think it's very common for a court's jurisdiction or authority over some pieces of a case to hinge over its ruling on other pieces of the case, on threshold questions. And that's all that happened here. This is a very
Mr. Brenton, you said the district court may have had jurisdiction at the outset. Isn't it clear the district court did have jurisdiction at the outset?
Yes, Your Honor, absolutely.
Okay.
Yes.
Okay.
At the
you
moment,
said may. I just wanted to clarify what your may meant.
Certainly, no. There's no question that both counts 1 and count 17 are covered offenses under the First Step Act. There was a hypothetical road the court could have walked down in which it chose to reduce count 1 and then maintain count 17 as a live controversy, but that's simply not the path that it took.
Let me ask you this. The second part of the argument here is that the court left in place what is now an illegal sentence with respect to count 17. The 60-year sentence that has been left in place is contrary to the present statutory maximum of 40 years.
Yes, Your Honor. So that is certainly the argument that Mr. Carrillo has presented. I think the government doesn't dispute that if Mr. Carrillo were sentenced today on just count 17, yes, his statutory maximum would be 40 years. And that there is an error in the answer brief on that point on page 15. And our apologies for that. It does not ultimately affect the outcome of this appeal, however.
Right. There's a math error, and oddly, I picked it up.
It is a numerical error that is a bit confounding. But as I say, it doesn't actually affect the outcome of this case. And I think to call that, though, an illegal sentence, I think stretches the law of this circuit pretty considerably. There's no question that the sentence of 60 years on count 17 was legal and within the statutory maximum at the time it was applied in 2000.
I mean, let me pick up on that and ask you a question. So these aren't self-executing laws. They're not laws that say, hey, if you were sentenced to 60 years for a crack cocaine offense, automatically your sentence is reduced to 40 years. These are sentences where people have to take action and petition the court for relief to correct it, correct?
That's absolutely right, Your Honor.
All right, so it's not illegal. It is subject to reduction, I guess, may be the better way to describe it.
I think that's absolutely right, Judge Carson. It could not be more clear under the First Step Act that the district court is not required to reduce a sentence pursuant to the First Step Act. It says it not once but twice. In 404B, it says the court may, not shall, reduce a sentence. And then in 404C, if that wasn't clear enough, it says nothing in this section shall be construed to require the court to reduce any sentence. So there's no requirement.
So you would say even if the only claim that was before us was a First Step Act challenge on count 17, in your view, the court would have had the discretion to leave the 60-year sentence in place, even though there is now a 40-year maximum, statutory maximum? Is that your position?
That is the position, Your Honor. Yes. The fact is the only authority that Mr. Carrillo has cited to the contrary is the Collington case from the Fourth Circuit. And with respect to the Fourth Circuit, that case goes squarely against the language of the statutes. And it's certainly not an issue that has been decided by this court. It's also not an issue that this court needs to decide today in this case. I think there's ample reason for this court to affirm based on the jurisdictional grounds that the court pointed to in its footnote. I'd like to also address the one bite rule point that was discussed during the opening. I think there really can be no doubt that Mr. Carrillo, should circumstances change in either the facts or the law, Mr. Carrillo will retain his ability to file a First Step Act motion as to count 17. You know, the language of the statute in 404C is that a second or a subsequent motion under the act is barred only where the district court has conducted a complete review of the motion on the merits. Now, that happened as to count 1 here, but it emphatically did not happen as to count 17. You know, I agree with Judge Carson. I read that footnote and I cannot read that footnote consistent with the conclusion that the court was conducting a, quote, complete review on the merits of the count 16 issue. Certainly the court...
do you see anywhere in the court's order where the court purported to reach the merits of the count 17 issue? I mean, I think the plaintiff or the defendant gets there based on the court must have decided this since they both involved crack cocaine, but is there anything explicit where the court reached the merits of count 17 as opposed to reaching the merits of count 1?
Absolutely not, Your Honor. In fact, the footnote that we're discussing is very nearly the only place that count 17 is mentioned at all in the order, except in the beginning in the sort of litany of the charges. In fact, how was the court explicit? The court was explicit to the contrary. The court was explicit that it was not reaching the merits of this issue and that Mr. Carrillo could bring it again. And that's completely consistent, by the way, with this court's footnote 12 in Manny, which says fundamentally the same thing, that the court's rejection of that defendant's motion was on jurisdictional grounds, was without prejudice, and in light of a change in facts, he could bring it again. So I think at this point, the district court, this court in Manny, and the government in the answer brief are all fully on the record as saying that he can bring a count 17 based First Step Act motion again. So I really don't think there's any reasonable basis to suggest to the contrary. Also, you know, to the extent the argument is, well, by making certain findings as to count 1, that also triggered the one bite rule as to count 17. I mean, the motivator of the court's decision on count 1 is self-evidently the amount of methamphetamine involved. You know, so the court's decision on count 1, the court even says, if I were to completely disregard the amount of crack, I would still read the guideline would be the same. And obviously that's not the case as to count 17. The two counts are very different. So I think that there's really no rational reading of the district court's order that suggests that the court conducted a complete review on the merits of count 17. And I just very briefly, I think the question of the concurrent sentence doctrine was raised. And I think, you know, Mr. Shaw's response was, if this is the concurrent sentence doctrine, then that's discretionary and not jurisdictional. That's correct as to the law, but the district court didn't apply the concurrent sentence doctrine here. It applied Manny, and Manny could not more clearly be an Article III jurisdictional case. And I think, you know, this court could say that this case is about mootness instead of standing, but we're still in the territory of Article III limitations on the court. So I think that the district court quite properly refrained from ruling on count 17 because it lost the authority to enter any order that would have any meaningful effect in the real world, and that decision should be affirmed.
Thank you.
There are no further questions.
I believe Mr. Shaw has some rebuttal time.
Thank you, Your Honor. As to Mr. Brenton's last point, the clarity of Manny was not even obvious to the district court in this case when it used words like Manny suggests that the court lacks jurisdiction to re-sentence Mr. Carrillo on count 17. The court uses a lot of this language, suggests and arguably, and creates this ambiguousness about what it's doing, and therein lies the problem for Mr. Carrillo. As to Judge Carson's point, and Mr. Brenton's argument that the First Step Act doesn't require anything, the district court to do anything, because it says nothing in this section shall be construed to require a court to reduce any sentence pursuant to this section. The authority for the court comes from 3582C, which puts the onus on the statute. And the statute here that compels the change in the sentence is Title 21, United States Code Section 841A1, which has changed and now has a maximum of 40 years applicable to Mr. Carrillo's amount of crack cocaine. And so even if the First Step Act says you don't have to use the First Step Act, it also says that you have to review the covered offense as if the Fair Sentencing Act was in place at the time. And the Fair Sentencing Act made Mr. Carrillo's count 17 offense punishable by a maximum of 40 years. And in our last 5 seconds, I'll just say, we ask that the court remand this decision to the district court with instructions that Mr. Carrillo's sentence cannot exceed 40 years on count 17.
Thank you. We will take this matter under advisement, and the court is going to take a short break. At this time, I show that it's 10. We'll be back in 10 minutes to hear our last 3 cases. Thank you.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
We're still waiting for another counsel. Here he comes. Okay. Mr. Pincus, you're having a little, can you talk again? We're having a little trouble hearing you.
Yes, can you hear me now?
Yes, okay. All right, so let's call, the next case is 20-6125, United States versus Bullcoming. And Mr. Pincus, we are ready when you are.
Thank you, Your Honor. May it please the court. My name is Howard Pincus from the Federal Public Defender, and I represent Tommy Bullcoming. The BIA agent who arrested Mr. Bullcoming turned him over to the marshals that Friday afternoon, September 8th, but took Mr. Bullcoming's duffel bag home with him for the weekend. He kept it through the day on Monday, September 11th, while he investigated the case, and then checked it into the BIA's evidence repository that night. His search of the duffel at that time was not a valid inventory search. Without what Agent Ware saw in the duffel on September 11th, the warrant affidavit did not contain probable cause. And because the admission of the evidence from the duffel bag was not harmless beyond a reasonable doubt, this court should vacate Mr. Bullcoming's convictions and remand for a new trial.
You said the September 11th inventory.
That's correct, Your Honor. Yes, Your Honor.
But the affidavit in support of the warrant talks only about the September 18 inventory. Isn't that correct?
Well, it talks about the blood that was found on Jordan's slides at that time. And if you take that out, then you would just have what's in the September 11th inventory. The government says that the September 18th inventory is proper as a second look, but it can't be a second look if the first look was improper, and that's the September 11th inventory.
There's nothing in Illinois versus Lafayette that says that either the September 11th or the September 18 inventory search were improper as inventory of searches, correct?
Oh, Illinois versus Lafayette says a booking inventory is permissible. And it says a booking inventory is an incidental administrative step following arrest and preceding incarceration, which takes place at the station house. This is something 3 days later. Now, in Colorado versus Bertine, the Supreme Court did say that Illinois Lafayette, the station house setting was not critical to its holding, but the context there really matters. What the court was doing was rejecting the Colorado Supreme Court's distinguishing of Lafayette about safety concerns at the jail. In that case, the Colorado Supreme Court said the same safety concerns don't apply to the impoundment of an automobile and the opening of closed containers in the automobile. The mere fact that the station house setting safety concerns are present outside of the station house setting doesn't mean that in Illinois versus Lafayette, the Supreme Court was blessing inventory searches that don't take place at the station house or reasonably promptly after arriving there. And it certainly couldn't apply to something 3 days later as here.
Let me ask you this.
Let me understand your position. Is your position that neither of these searches are qualify as inventory searches because, number one, they were done remotely, and number two, they were done well after the arrest of the defendant? Is that your position?
That's correct, Your Honor.
And where's your authority for either one of those two disqualifications?
Illinois versus Lafayette talks about this booking inventories, which is what this supposedly was, being an administrative step following arrest and preceding incarceration. And we have this well after. And the purposes that an inventory search is meant to serve are furthered when those interests are ensured when there is a prompt inventory at the station house.
But wait a minute. Here we have basically somebody this Micah Ware, is that his name?
Correct, yes.
Who is able to actually give custody and control testimony that establishes the whereabouts of this bag at all times through September 18th. And it verifies that what is in there. And just because I don't understand why it's important that it's not done at the station, because it satisfies the purposes of Lafayette. And that is, it satisfies the fact that jail employees can't steal stuff of incarcerated defendants. And it protects the jail and the administration for fraudulent claims by an incarcerated person that his goods have been stolen. It satisfies all those things, and that's the purpose of inventory search. So I don't understand why this shouldn't qualify.
That is the purpose, but this doesn't satisfy. The court in Lafayette said it's not unheard of for police to take things out of property, and we need to protect the property, and we need to protect against false claims. And that's done by a reasonably prompt inventory. And as the court said in Lafayette, and I'm quoting here, a standardized procedure for making a list or inventory as soon as reasonable after reaching the station not only deters false claims, but inhibits theft or careless handling of articles taken from the arrested person. And that's not satisfied here, where we have a three days that the bag is in Agent Ware's possession with nobody else around. Mr. Bullcoming's not there. No other officers are there.
Mr. Pincus,
it necessarily compromise those interests.
If instead Mr. Ware or Officer Ware had put the bag unopened in a locker in the evidence room at the police station, waited 3 days, took it out and inventoried it, would you still have an objection saying that it wasn't a proper administrative inventory search?
I think we would, because we don't know who else could have access to that locker.
I said it's in an evidence locker. It's in the evidence room. It's in a locker, and it's controlled access. So no one else has touched it. Mr. Ware comes back 3 days later when he has time, and he inventories everything that's in that bag.
Well, the whole point of doing it at the time is to
answer my question first.
Right, but it's to guard against that misconduct, and misconduct can occur in the type of scenario that you're positing, Your Honor. And in any event, what we have here is something entirely different. We have him taking the bag home, certainly an unusual thing.
What I'm trying to get you to focus on, first I want to understand your argument. Is your argument just time passed, or is that it was uncontrolled during the time that it passed? It seems to me if you have it controlled and no one else has access to it, the fact that you later inventory it doesn't in any way impact the Lafayette rationale.
Well, Lafayette does say as soon as reasonable after reaching the station. And it's not as soon as reasonable if they put in a locker and do it 3 days, 3 weeks, 3 months later.
It depends on what was going on in those 3 days, doesn't it? It's not always unreasonable, is it?
Well, I think what the Supreme Court was doing in Lafayette was saying, here's an easy to follow rule. Do it as soon as you get to the station house. And that eliminates all of these collateral inquiries. But in any event, even if you posit that there are some scenarios where that might be okay, it's certainly not this case where the officer takes the duffel bag home with him. And we only have his word about things. And then he takes it while he's investigating the crime.
But what's wrong with just having an officer's word about it? You can cross-examine him. Actually, the facts in this case seem to me more reasonable than even the hypothetical Judge McHugh stated. He was locked up in his car because, under the circumstances, wasn't it reasonable for him he'd been up for 2 days or something, to just go home and leave it locked in his car and nobody had access to it?
Well, no. First of all, the rule of Lafayette is there because there is a recognition that police sometimes engage in misconduct. Second, what should have happened is his bag should have gone with him to the jailers, and the jailers were the federal marshals. Instead, Agent Ware took it with him. And he even acknowledged that if this were evidence, and of course the duffel bag wasn't evidence, it was Mr. Bullcoming's property, what the rules required was for him to check it in that evening. He didn't do that. He waited 3 more days, took it home with him, investigated the case. That's not following procedure. That's not reasonable under Illinois versus Lafayette. Now,
let me turn you, because you're running out of time, to the issue of whether, even if we were to eliminate from the affidavit everything that was learned from the inventory search, isn't there enough in that affidavit that they had probable cause?
No, they have probable cause. They might have probable cause to believe that Mr. Bullcoming is involved in the events of September 6th, when there was the arson and the murder. What they don't have is a fair probability that the bag will contain any evidence of that. And the reason they don't have that is Mr. Bullcoming's actions at his arrest. He affirmatively asked that his bag be brought with him. He already knew that the police suspected him of the arson. And of course, if he was the perpetrator, he would know there was a murder as well. And
well, I guess that assumes that he knew there were traces of blood on some of his clothing. And
he would just,
and I think it's fair to assume that he didn't think there was blood on the clothing.
If he even thought that the only evidence was that this murder was very bloody, if he even thought that there was anything in the bag that might remotely link him to the events of that evening, he certainly wouldn't have asked that the bag be taken with him. He wouldn't have put it in police hands. And that's the problem. That's what makes it unreasonable to think that the bag would contain any evidence of the events of September 6th, of that night with the arson and the murder.
Do you have any evidence? Oh, I'm sorry. Go ahead.
Do you have any case law that gets where you're going on that? Because it sounds to me a lot like a person who has drugs in the trunk of their car, and the police say, do you mind if I take a look back there? And they're like, oh, well, by all means, look. And then they open it up and there's some drugs there. And they say, well, I didn't know that was there. And the proof is that I told you to look there. I mean, that's it. Do you have anything, that would support what you're saying as like from a case?
Just a fair probability standard. And the difference in that case is the person there may think, if I don't answer the question, that will look suspicious. If I don't give permission, that will look suspicious. I might as well take my chances. Here, the police said they were going to leave the bag there. Mr. Bullcoming affirmatively put it in police hands. Why would he do that if he even remotely thought that it might contain anything that might conceivably connect him to an arson, and if he was the arsonist, a murder?
Maybe it's because that medication that was in there was very important to him.
Well, the medication there's no reason to think that the medication was that critical. And if it was that critical, he could have asked somebody to get the medicine for him. If the choice is between some medicine and implicating yourself potentially in an arson and murder, it seems that the choice is clear, and there's not a fair probability to think that the bag would contain evidence of the murder or arson.
Mr. Pincus,
go ahead.
Was there any evidence about the other contents of the bag, and that is the other clothing items? Was there any evidence that he was wearing that on the 6th or 7th of September?
I don't believe there was, Your Honor, no.
So the only evidence about the content is the evidence of the medication and the evidence of these gray slippers, flip-flops, or sandals, whatever they were.
Well, we know what was in the bag, but if you're asking, was there anything that connected those to the events of that night?
Yeah.
There wasn't. But if he was wearing those slides, then, and it was a bloody crime, all the more reason to think, why would you turn this over to the police and put it in their hands? I see I'm running out of time. I'd like to reserve a few seconds for rebuttal, so we would ask.
But let me ask you, the blood on his belt, that was his blood?
That blood was never connected to anything.
Okay, so we don't know whose blood that was.
They weren't able to tell, right?
I don't think it was thought to have anything to do with the night's. I mean, okay. I don't know if there was any proof as to when it came to be on his belt, or certainly it wasn't linked to Ms. Zotai.
Right.
So we would ask.
I'm going to ask another question. So I'm going to ask the panel to indulge me. What do we do with the fact that he gave permission to a police officer to go through that bag, and the police officer took everything out in order to look for the medicine? I mean, it doesn't look like he had much of an expectation of privacy if he said, hey, go ahead, dig through my bag.
Well, that's actually not what he said. He said that his medicine was in the outside pocket. The officer said, I couldn't find it there, so I emptied out the bag. There's no indication that Mr. Bullcoming was saying, go into the bag. And there was no proof that the
he did it with Mr. Bullcoming standing there. They were still, he said it was right when they were coming in from the garage, as I understand the testimony. And my sense of it was that Mr. Bullcoming standing right there as he's digging through the bag looking for the medicine. I don't recall any instance where Bullcoming saying, hey, I said you can only look in the outside pockets.
No, he didn't say that, but he did say my medicine is the outside pocket. That was his expectation, that the officer would look where the medicine was. And in any event, what the agent saw at that time, there's no way to find on this record that it included the Jordan slides. The prosecutor didn't ask about that. He gave very ambiguous testimony about what was possibly in there. He never said the Jordan slides. And the prosecutor asked, on September 18th, when you did the second inventory, after the September 11th inventory, did you know there were slides, the Jordan slides in there? And of course, by that time, he knew from the September 11th inventory. So we would ask that this court vacate Mr. Bullcoming's convictions and remand for a new trial without the evidence that was in the duffel bag. Thank you.
Thank you. Mr. Krager.
Thank you, Your Honor, and may it please the court. Stephen Krager on behalf of the United States. The district court properly denied Mr. Bullcoming's motion to suppress, and this court can take one of two avenues to affirm that ruling. First, as the court indicated through its questionings, one avenue is what the district court did here, and that's to excise the one sentence in the search warrant affidavit that deals with the September 18th search and the numbers related to the specific numbers of clothing in the attachment B. And then review.
Let's stop on that one first. So as I understand Mr. Pincus's response to that, it is that, well, if you excise that information, you might have probable cause that he was involved in this murder, but you don't have probable cause to believe that any evidence of his involvement would be found in the duffel bag.
Well, yes, Your Honor. So I think there are two responses to that. First, I think Mr. Pincus's argument, if I remember correctly, is that probable cause was vitiated by the fact that Mr. Bullcoming asked Special Agent Ware to take the bag with him. And I think Judge Carson's scenario was something that I was actually going to bring up, which is this court's cases and Supreme Court cases are full of instances where defendants give consent to search, where they have kilos of drugs, where they have ample evidence of crimes and the locations they consent to search. So it defies judicial reasoning to say that there can't be probable cause simply because Mr. Bullcoming asked that the bag be taken with him. The second has to do with the fact, and this was laid out by the district court in its orders, at least two specific facts that were observed by Special Agent Ware that were included in the affidavit that give at least a reasonable probability that DNA evidence would be found. The first is Special Agent Ware saw a surveillance video that recorded Mr. Bullcoming approximately 1 hour after the murder and arson, in Elk City, and he had blood on his right palm and his left ring finger at the time. And then when he was arrested, some 27 hours later, he had several cuts and scrapes on his arms, hands, and legs, a swollen right hand, and blood on his belt, indicating not only the blood on his belt, that there was blood on clothing, but that there was blood on his both hands an hour after the murder. There wasn't blood on his clothing, and so presumably he either would have reached into the bag or he would have had to retrieve some sort of clothes. Whether or not the precise bloody clothing would have been in the bag is ultimately irrelevant. The question would be, is there any testable DNA there? And the district court could reasonably infer that based on the blood on Mr. Bullcoming's hands, there would be, and the blood on the belt 26 hours later, that there would be testable DNA on the clothing inside the bag. So in addition to that, Special Agent Ware was aware that there was clothing in the bag. First of all, whenever Mr. Bullcoming was in custody in El Reno, and this is at page 78 of Volume 4 of the Record on Appeal, Mr. Bullcoming asked Special Agent Ware to retrieve a shirt from him from that bag. And then, as has been noted in Mr. Pincus's argument, there was the entire situation in the Marshall Sally Port where Mr. Bullcoming had asked for medicine. Special Agent Ware couldn't find the medication in the pocket, and so he dumped out the contents of the bag trying to locate the medication.
But let me ask you this, and this sort of goes to a question that Judge McHugh was asking Mr. Pincus earlier. And where does consent come into this? Because is there a point at which Mr. Bullcoming authorized entry into that bag so many times that he lost his expectation of privacy in its contents?
I think under the second look doctrine, this court could say, because the entire purpose of the second look doctrine, I think, goes to your point, Judge Carson. The second look doctrine essentially says police have already reached this expectation of privacy and had the authority to do so. And so they're not going any further than the search they've already committed. So all of this was already laid out. And there was a consent search. And my understanding is Mr. Bullcoming doesn't challenge the consent search in the Marshall Sally Port. And so the second look doctrine could cover all of this. And I think that would be my answer to your question, Judge Carson.
Okay.
But the court doesn't ultimately have to consider the second look doctrine, or the second look doctrine would only apply to the second avenue. And I think that, again, would be a proper way of looking at it, and a way of disposing of the case. Alternatively, if we want to start with the September 11th inventory search, the government would submit that was a proper inventory search. Mr. Bullcoming has argued that Lafayette controls this case, but what Lafayette did was take a discrete factual scenario. The inventory search occurred after arrest at the station house before being booked in. Lafayette relied upon, or cited without overruling, so cited favorably, cases like Edwards, where there was a 10-hour delay after booking. There are additional cases, such as John's, where there was a 3-day delay between the seizure of the boxes there and the warrantless search. Cooper is probably the most applicable. Cooper dealt with a seizure of a vehicle that was ultimately going to be forfeited, and the vehicle wasn't inventoried for a week. And the Supreme Court explained that the rationale for the inventory search still existed because police were going to be keeping the vehicle for at least 4 months. The same
Does it matter that here, I mean, all of these other cases, it's the police that are holding the item to be searched. And so they have control of it. Here, you know, the sheriff throws it in the back of his truck and drives it home for the weekend.
Well, Your Honor, would I have preferred that Special Agent Ware checked it into the police, into evidence lockup before he went home? Yes. I think probably the most direct answer to that is he testified at the suppression hearing that it was secured in the hard back portion of his truck, that he was the only one that had any keys.
So, as I understand your argument, you're saying it goes to the chain of evidence, the control of the evidence, and might be a grounds for cross-examination or impeachment, but that it doesn't affect whether it's a legitimate inventory search.
I think that's correct. And I think that there are two independent interests in conducting an inventory search. Yes, Special Agent Ware may have opened himself up to allegations between when he took the evidence home and when he conducted the inventory search on September 11th. But the BIA has a separate interest once it's checked into their evidence lockup. And so as part of checking it into the BIA evidence lockup that occurred on September 11th, Special Agent Ware had to conduct an inventory search.
So as I understand, he is part of the tribal police, right?
He's a BIA special agent.
Okay, and so he would use their facilities to secure evidence in much the same way a county would in securing evidence that was ultimately used in a federal prosecution. Is that fair?
I believe so, yes.
Right.
And I want to ask you about the September 18th search.
Okay.
I have concerns about that being a legitimate inventory search because the purpose was clearly investigatory. It was to support the search warrant affidavit, and it wasn't just administrative to try and protect the officers from a claim of stolen property or a claim by the defendant that there was more property. I mean, isn't that a very different animal than the September 11th search?
It is very different. Special Agent Ware testified that the reason he conducted the search wasn't to root around looking for evidence. What he was doing was getting the specific quantities of clothing to include in the attachment B to the search warrant affidavit. Again, if I were advising him,
the purpose is very different at that point than it was on the September 11th. I mean, except September 18th, the purpose of that search is to support the investigation and prosecution.
Correct, and that's why ultimately we're relying on the second look doctrine to support the September 18th search. If I were forced to...
When you say that, Mr. Krieger, on the second look, are you saying the first look was at the time of the arrest, or the first look was on September 11th?
Well, yeah, I think there's an argument that there were about 3 first looks that were supported, 2 by consent, the first in El Reno, the second at the Marshall Sally Port, and then the third on September 11th.
What was this? What was the second?
The second was
when he got the shirt.
Port.
So the first would have been when he got the shirt in El Reno. Mr. Bullcoming asked for a shirt in El Reno, and Special Agent Ware retrieved it from the bag. The second would have been, and I think is probably the most comprehensive one, would have been when Special Agent Ware, in looking for the medicine, dumped out the entire contents of the bag, and saw everything that was in there on September 8th, and that would have been in Oklahoma City. And then the third one would have been the inventory search on September 11th. The first 2 would have been supported by consent. The second one, or the third one, the one in the inventory search would have been an inventory search, not a consent search. And so as far as the second look doctrine, what we need is going no further than police had already gone, and dumping out the entire contents of the bag on the Marshall Sally Port floor was no further than what Special Agent Ware did whenever he was going through taking an inventory, or setting forth in the attachment B, so to avoid using the word inventory, setting forth in the attachment B the precise contents of the bag. If there are no further questions on the suppression issue, I know there's a second issue that Mr. Pincus didn't reach. I'm happy to answer any questions there might be on that.
Do you want to talk about harmless error or not?
I think harmless error largely set out in the brief. The only thing I'll mention about harmless error is, as far as the search goes, as far as the suppression issue goes, is that the connection that the DNA evidence from the bag brought was to put DNA evidence of Mr. Bullcoming and Ms. Zotai together. And that was still provided, and this is pages 1147 and 48 of Volume 4 of the Record on Appeal. That same link was established by DNA in Ms. Zotai's vehicle.
But this evidence of blood on the slipper, slider, whatever it was the only evidence of the victim's blood in the case, correct?
I would have to be, I'm not 100% sure, but I believe there was blood evidence in her vehicle as well.
Oh, no, okay. That is associated with the defendant or his belongings. The only blood of hers was on this slipper, correct?
I believe that's correct.
All right, and the evidence was pretty clear, at least as to the condition of the victim, this was a pretty bloody event.
Yes.
Correct?
Yes, she was stabbed multiple times.
And so if the only evidence of the victim's blood that's associated directly with the defendant or his belongings is eradicated, isn't that a real problem? Doesn't that indicate that the error was not harmless?
Well, Your Honor, I think it becomes a very close question. I would still submit that there was the DNA link from the blood that was in Ms. Zotai's vehicle as well. And if memory serves me right, and I'd have to double check on pages 1147 and 48, that there was DNA from both Ms. Zotai and Mr. Bullcoming. It's been a few days since I've read those pages, and so I can't confirm that 100% accuracy. But in the end, the court doesn't need to reach harmlessness because either the affidavit on its own is sufficient or the searches were permissible under the law. Unless the court has any further questions, I'd ask the court to affirm the judgment and sentence below. Thank you.
Thank you. We will take this matter under advisement, and we'll turn now to our, I think this one's on the briefs. Yes, we'll turn now to United States versus Diaz, and that is 20-1269. Let's see, and I guess, Mr. Pincus, I think it's you on this one.
It is me, Your Honor. May it please the court. My name is Howard Pincus from the Federal Public Defender, and I represent Hide Diaz, who actually prefers to go by Silvio Amador. Mr. Amador was treated differently than others who are in his situation, who are facing state charges and are indicted for illegal reentry. He was not even arraigned on the federal charge until almost a year after it was brought. This delay meant that he lost the chance that most in his situation have and exercise to resolve the federal case first and to avoid a large guideline increase. As a result, there was unwarranted disparity with others like him, and his sentence is substantively unreasonable. The way it typically works in this circuit is in accordance with this case's decision in United States versus Seltzer. In this circuit, prosecutors will typically move an indictment well in advance of a year so they can bring the case to trial within a year. Because if they don't, there's a presumption that the delay is prejudicial for speedy trial purposes. And this court made clear in Seltzer that the mere pendency of state charges does not justify delay. There has to be a particularized showing of a reason for the delay.
But this isn't a speedy trial case.
No, it is not.
You haven't made a speedy trial. So I'm not sure that the speedy trial analysis in your brief is all that relevant here.
Well, if we were making a speedy trial claim, of course, we would be asking for dismissal. We're not asking for that, and we never did. What we're what we were pointing out in the district court and what we're arguing here is that the way that this case was handled is different than the norm, and the norm is how it would be handled in accordance with this court's speedy trial jurisprudence. So that's what resulted in the unwarranted disparity. The fact that Mr. Amador was not brought into federal court promptly or anywhere even close to promptly, and that as a result, he didn't have the advice of a federal lawyer who would say, you shouldn't resolve the state court case first, you should resolve the federal court case first because of the huge difference in the guideline range. The fact that he resolved the state case first meant that he got an 8-level increase in offense level and that his criminal history category went up 1. Instead of being in a 27 to 33 month range, he was in a 70 to 87 month range. And that's huge, obviously. And one would expect that if the prosecutor here had some valid reason for delaying an indictment that he brought, remember, the federal government didn't have to charge Mr. Amador when they did, but they did. They decided to proceed on this case. And once they did, they had an obligation to proceed in accordance with this court's authority. And if the prosecutor had any reason that might justify waiting until after the state case resolved, which was pretty much 11 months into the 1-year period, and he didn't even secure Mr. Amador's presence until 2 days shy of 1 year, making trial within a year impossible. If he had some good reason for this delay, one would expect that he'd be able to articulate it. And he couldn't. All he ever said was, we're well within our rights to wait until resolution of the state case. And that's not a good reason under Subser. So if this case had proceeded as these cases typically do, with the prosecutor abiding by this court's speedy trial instructions, Mr. Amador would have had the chance to resolve the federal case first and not the state court case first. That's what leads to the unwarranted disparity here. Unlike others in his situation, he faced a dramatically higher guideline range. And that creates unwarranted disparity that between what somebody in a situation would typically be facing, 27 to 33 months, and what he faced, 70 to 87 months. And there's nothing here apart from that would justify a sentence as long as a district court gave. The court spoke about deterrence, but the only deterrent that Mr. Amador had come back to this country previously, and he had come back a few times, and he had an illegal reentry conviction. His illegal reentry sentence there was 16 months, far less than the 63 months the district court imposed would have served deterrence more than adequately. And the guideline range of 27 to 33 months indicates that. And Mr. Amador's criminal history, apart from the illegal reentry, is fairly minor. He has a false information and trespass conviction from 2004, for which he got 3 days. He had a possession of a controlled substance in 2005, where he got 2 years probation. It was revoked, and he got time served where he got 90 days. He has a false information from 2009 where he got 90 days. He has that illegal reentry case of 16 months and a DWAI with 12 months of probation where it was revoked, and he got 298 days, which was the equivalent of time served. So there's nothing in his criminal history that would justify a sentence of this length for illegal reentry. There's nothing in deterrence. It's driven largely by the guideline range. The guideline range that, true, it's the correct guideline range because his state case was resolved first. But if this case had been handled as defense counsel represented is often the case, where federal prosecutors proceed on indictment promptly, it would have been less. And even if you can't say, well, it's typical that they bring them in very quickly, certainly where they wait close to a year, and that's what causes a state case to resolve first. That's inconsistent with what this court is instructing.
It sounds to me like what you want the defense to, your argument is that, listen, there are serious consequences to this state court conviction, and had he known about the federal charges earlier, had they pressed those earlier, he could have gamed the state court, sought extensions, tried to drag it out as long as possible to keep the state court conviction from becoming final, in an effort to undermine the sentencing options of the federal judge. I mean, that sort of, you're gaming it one way or another, aren't you? I mean, you're claiming the government's gaming it by not filing, but I mean, they could claim that you're gaming it by wanting to delay the state court proceeding and not pleading guilty.
Well, they're the ones with the obligation to proceed promptly on the indictment. And that's what they typically do. And that's what they should have done under this court's decision in Seltzer. Then it's for Mr. Amador to decide how should he reasonably resolve these cases. He may have had a defense to the state case and thought, well, I'll accept the 2 years and that'll be that, not knowing that there was a federal charge in the offing and that his plea in the state court case would jack up the federal sentence from 27 to 33 months, the guideline range, to 70 to 87 months. He is the one who should be apprised of what charges are pending against him so he can make informed decisions with his counsel, state and federal, as to how best to proceed. And he was deprived of that chance by the prosecutor's delay that they did not offer any justification for.
But you didn't make a speedy trial argument, and so they didn't have to justify their delay. And by the time it gets to the sentencing judge, when he's looking at, he or she, I don't remember, looking at disparity, it's not disparity by the whole world of people out there. It's disparity among people with the same criminal history record. And while it would have been nice if the criminal history were different, what the judge was faced with was the actual fact that he had been convicted in state court. So I don't know that you can say the court ignored disparity, because the comparator you want to use isn't the comparator that you use in that situation.
Well, this is a unique situation for such a comparison. What we're saying is the comparison needs to be with those who were charged like Mr. Amador was charged, and what typically happens in that situation. And in this circuit, we know what happens, which is prosecutors can be expected to honor their obligations, and they will bring people to trial or bring them at least in for arraignment well in advance of the 1 year, so that if there's going to be a trial, it can actually happen within 1 year. That didn't happen here. And the prosecutor did give his reasons for his inaction. This was a basis for the request for a variant sentence. And the prosecutor said, we're well within our rights. We could wait till the state court case resolved. And that's not what could happen. That's not a valid justification under Seltzer. There would need to be other reasons, and there's nothing here.
If you were making a speedy trial argument, I think you'd be heading straight down the path. I think the problem here is, let's make a few assumptions. Let's assume he didn't plead guilty in the state court prior to federal sentencing, and he's at sentencing, and the prosecutor says, Judge, I want you to vary upward because Mr. Amador is facing these state charges. And if he's convicted and the evidence is strong, here is the evidence, and the prosecutor puts on some evidence of what he's looking at. And he says, if he's convicted, then he would be subject to this higher guideline range. And the lower guideline range urged by Mr. Pincus is underrepresenting his criminal history. So you should vary upward. I mean, what would you say to that?
Well, of course, the court can vary, and the court could consider all of his criminal conduct or really any information in imposing a sentence. So is such a variance possible? Yes. Yeah. We don't know that it would have happened here. We don't know.
I mean, the court could have varied here. Your client asked for it. The evidence of the government delay was put on. The government gave a weak excuse for waiting a year. I mean, maybe even telegraphing that they were hoping to pop Mr. Amador with a bigger sentence, and the district court said no. Right. I'm not going to vary downward like that. I am going to come down, but not like you want me to.
And if we were making a procedural reasonableness argument, the fact that the district court considered the variance request would be the end of the matter. But we're not. We're making a substantive reasonableness argument, of course. And back to your point about the possibility of the district court varying, if this case had been resolved first, it wouldn't support a variance anywhere close to from 33 months up to 63 months. And if the court had varied, we also don't know if the state court, if they would have proceeded on that or would have said, well, they've already gotten their pound of flesh from Mr. Amador based on considering that fact in his federal sentencing, certainly what a state court lawyer would argue and might advise him to reject the plea. His plea for the trespass was right in the middle of the 1 to 3 year presumptive range for that case, 2 years. And the drugs that were found were a very minor amount. I think it was 0.13 grams of methamphetamine that were dropped. So it's certainly possible if the federal court had varied, like Your Honor suggests, that the state court proceedings wouldn't have resolved as they did, or that the sentence would have wound up being concurrent and that he wouldn't have had the additional time that he had from the state court sentence. So I think those are very likely possibilities. We would ask that this court vacate Mr. Amador's sentence as substantively unreasonable and remand for resentencing, for the district court to take into account the unwarranted sentencing disparity here. Thank you.
Thank you. Ms. Milani.
May it please the court. Elizabeth Ford Milani for the government. The guidelines range in this case was 70 to 87 months in prison. The district court sentenced Mr. Diaz to 63 months. Mr. Diaz is not challenging that guidelines calculation based on the facts that were before the district court. And he's made clear he's not raising a speedy trial challenge. So the only question this court must answer is whether that below guidelines sentence was within the realm of rationally available choices. It was. Mr. Diaz's key argument is that the sentencing court should have imposed a 30-month sentence to avoid disparities between Diaz and other defendants who were immediately arraigned after indictment. Judge McHugh, I think that you summarized the response to this position perfectly. That's just not the disparity inquiry under 3553A6. It examines defendants with similar records and convicted of similar conduct. Here, Mr. Diaz's record includes the state trespassing conviction. So the comparison under the disparity inquiry would have to include some defendant with a similar record as Mr. Diaz in this case.
But doesn't that give the government quite a lot of power by delay to change the comparators so that they treat in practical effect, they are treating Mr. Amador differently than most other defendants in this situation?
Perhaps, Your Honor, but I think it's worth pointing out that because a speedy trial issue was never raised in the district court, Seltzer didn't sort of trigger the prosecution to make this explanation as required under Seltzer to set out why they were delaying. And there could have been very good reasons that they just aren't in the record because Seltzer didn't apply, is our argument. But
this is not a speedy trial argument, is it? It's
Correct.
Saying that the speedy trial issue makes clear the disparity here. I mean,
I'm not sure I follow you.
If he was treated as others are in order to deal with the Speedy Trial Act as the government normally does, is that he would not have this high of a range. So he's not making precisely a speedy trial argument. He's saying that if he had been treated as others normally, that he would have gotten a lower sentence.
Right, Your Honor. And I think the response to that is there could have been good reasons for the government to delay the arraignment in this case. But because the defendant didn't raise the speedy trial claim specifically, Seltzer didn't trigger the government's requirement to explain why the delay was occurring. So I guess I agree sort of to your point, but I think that there could have been good reasons. And I think that in this case, because that triggering event never occurred, we don't know those reasons. But as it stands, 3553A6 looks at the criminal record. Here, Mr. Diaz's criminal record included that state trespassing conviction. So comparing him to the hypothetical typical defendant in this circuit really doesn't get him very far, because what we're looking at is defendants with similar records convicted of similar conduct. And he doesn't put forth any specific case in which there was a huge disparity. Here, the district court varied downward based on the sentence imposed in the state trespassing case and the anticipated guidelines range that was put forth in the plea agreement. It highlighted two sentencing factors justifying that sentence, like deterrence, as well as the fact that the court was concerned about protecting the public. The district court also explained why it declined to vary further based on the prosecutorial delay, separate from the speedy trial analysis. First, the court pointed out that Mr. Diaz didn't have some inherent right to dictate when the prosecutions would occur. And second, the court said that Mr. Diaz's argument at bottom effectively required the district court to ignore his state trespassing conviction. And it didn't think that it had the authority to do that. It didn't see that
With respect to the first reason, I mean, in fact, Mr. Diaz does have an inherent right to with respect to when he's prosecuted, and that right is under the Speedy Trial Act.
Certainly, but because he did not raise that right, I think that that's where that falls flat. That argument falls flat. He didn't argue.
But I mean, he didn't raise it, but it doesn't seem to me it's a very valid point in the district court's analysis to say that the right didn't exist. He may have waived the right, but he had the right.
Certainly. Yes, Your Honor, that point well taken. But I think that the fact still remains that because this right was not asserted, we don't know why the government delayed. It's not in the record. So there are, just as in Seltzer doesn't foreclose the possibility that the federal prosecutors can wait until the state prosecution ends and still be consistent with the Sixth Amendment. In fact, Seltzer just says you need to have a good reason to do it. And it's possible that there was a good reason to do it here, such that there would be no Sixth Amendment violation. And I think that that's how the district court record can be read holistically in that regard.
I mean, it seems to me that in the absence of pressing a speedy trial violation, that the manner in which Mr. Pincus's argument should come up may be in the 3553 context, and that obviously Mr. Pincus's client chose not to raise the speedy trial claim, so they have to live with the timing of the convictions. But there's no reason at sentencing why they couldn't urge a downward variance based on this. And in some cases it could be compelling and interesting argument to present. And the district court is able to agree or disagree and either vary downward or not. What do you think about that?
I think that that is borne out in cases. I haven't found any in the 10th Circuit, but in other circuits, namely the 7th Circuit, courts have considered that prosecutorial delay. But in those cases, the district court found that 3553A factors other than that delay were simply more compelling. So it rejected the defendant's argument based on that delay. And I think that you could read that from the record here too. The defendant, while not pressing disparity particularly hard, I went back and looked in the sentencing transcript, and the word disparity only comes up once. But that argument was before the district court, but it simply found that there were other circumstances of 3553A that were more compelling, those being deterrence and protecting the public. So certainly, I don't disagree that such a delay could be considered, but here the court considered it and just rejected the defendant's argument. That's not to say that the defendant didn't get some sort of credit here. Recall that the district court did vary downward by 7 months from the bottom of the applicable guideline range. It just didn't do so based on that disparity point. And I think that was well within its discretion.
But the defendant asked for 30 months variance, correct?
Yes, Your Honor.
And gave arguments why he should get it. And part of the arguments was this very thing, and that is he was not charged, he was not arraigned until 11 months after he was charged, correct?
Right.
Now, you say that Seltzer only requires an explanation by the prosecutor of why they delayed. Why didn't the facts of this case that you just acknowledged require, in fairness, that the government say why they delayed 11 months?
I just don't think that language is in Seltzer. It's very clearly a speedy trial
I know. I'm not talking about Seltzer was a Speedy Trial Act, right?
Right.
Case. Everybody says it's not a Speedy Trial Act case.
Right.
Mr. Pincus says that. Everybody understands that. But it is a case where it's very clear in the sentencing that the guy gets a much higher range than he would have gotten had it proceeded earlier, correct?
Correct.
That's right?
Correct.
Don't those facts suggest that, quite aside from Speedy Trial Act, quite aside from Seltzer, in the interest of fairness, the government needs to come forward and say why they delayed 11 months between indictment and arraignment?
Perhaps that would be a good practice, but I just don't read the case law as requiring this. Under Seltzer or any other, until that argument is raised, I don't think that the government necessarily has an obligation to head off every single potential argument.
Well, is this court supposed to encourage better practice in its decisions?
Certainly. Yes, Your Honor.
Well, then would that suggest that a decision in this case should be that the appellant is correct, and maybe the government would undertake better practices?
Certainly, Your Honor, but I think it would be quite the departure from, I'm just not aware of case law that requires this. And so I think that setting forth this requirement where none existed on prosecutors at the time of arraignment, indictment, and those sorts, and making this record that isn't required yet, I think that would be.
I'm not saying that you're required to arraign right soon after indictment. What I'm saying is that if there's a delay close to a year, maybe you should be obligated to explain why that happened.
I think that would be a departure from this court's precedent. And so I think that requiring that for the trial AUSA in this case, or rather the plea AUSA in this case, would be a departure.
Oh, how about this? Go ahead.
No, you go ahead.
Well, I was going to say, how about the idea that if Mr. Pincus's client raises this at sentencing and the government doesn't explain, that the trial judge is free to say the government has no good explanation for why they delayed, and so therefore I'm going to grant the departure because the government failed to justify their delay?
So I guess I would wonder how that would come up in terms, or how that would be required under the law as it stands. But I do want to make the point that—
Well, I'm asking you if it would be permissible. Wouldn't it be permissible? Mr. Pincus gets up and he says, Your Honor, the guideline range is 77 to 87 months. It's patently unfair because they delayed a year in bringing my client into federal court after they indicted him, and they had no reasonable justification for doing so. And the judge says, Ms. Milani, what's your response? And you say, well, we were within our rights. And the judge says, oh, not good enough. I needed an explanation. You gave me no explanation, so I'm granting the downward variance. I mean, wouldn't that be appropriate?
I suppose the judge could do that, Your Honor. But what I would point out is that this argument is made in the context of the disparity factor under 3553A6. That's the circumstance in which Mr. Pincus and Mr. Diaz raised this claim. Even if the government didn't have a very good reason, let's say, the district court could still conclude that the other 3553A6 or 3553 factors were more compelling than that bad reason that the government gave. So I don't think that would necessarily warrant a variance that the defendant requests in every case. I do think it's worth pointing out that this is all a totality of the circumstances analysis. And even if the government's rationale for delaying was lacking in the district court's view, that doesn't mean that the defendant is entitled to the sentence that they seek. Especially
no, but the very hypothetical you put out, what would happen at a sentence after this is raised, then the court could go on to 3553. That didn't happen because the government didn't come forward and say, well, this is why we delayed.
So in that case, Your Honor, are you asking what the district court would do in that scenario?
I'm just saying that your hypothetical would be different if they had come forward, the government, and if they'd been put to the burden of showing why they delayed, and they gave no good explanation.
But again, I think that would still fall under, was this defendant treated unfairly with regard to other defendants? And does that fall under the disparity? And disparity is just one of the factors that the court is to consider in sentencing a defendant. So there could be other factors. For instance, the court specifically cited deterrence here and the necessity to protect public safety, that those could have outweighed any sort of bad representation or lacking or insufficient representation by the government as to the rationale behind the delay. So I think that in this case, the court did exactly what it was supposed to do. It balanced the arguments, considered them. It gave a cogent and reasonable basis for the sentence that it gave. And it it varied downward from the guidelines that the defendant doesn't dispute applied here. So for all these reasons, the sentence was substantively reasonable, and it is entitled to deference from this court. This court should affirm Mr. Diaz's sentence. Thank you.
Thank you. I think, Mr. Pincus, you have 1 minute and 4 seconds.
Thank you, Your Honor. Just very briefly, Mr. Amador raised in the district court Seltzer. He argued that the failure to comply with Seltzer resulted in the guideline range being markedly higher. That's at volume 1, pages 38 to 39. And it's not that the government didn't offer a reason. They offered a reason in response. And the reason was, we have the right to wait. And that's not enough under Seltzer. Just one other point, which is that the district court said it was varying for one of 2 reasons. And the other reason was that Mr. Amador was, although the court didn't accept his argument that his criminal history category was overrepresented, it did think that was a reasonable argument, and that if it had used a category of 5 rather than 6, it would have gotten to a lower sentence. I think that suggests that any large variance here from the range that would have applied if Mr. Amador had been treated like others in his situation wouldn't justify a variance anywhere close to getting you up to the 63 months that the sentence here was, and the sentence is substantively unreasonable. Thank you.
Thank you. We'll take this matter under advisement, and the court will be adjourned. Would the panel please stay on for